3, 2, 1. Okay. Hello. Hello and welcome. Hello and welcome. Welcome to the Empowered Immigrant Live. Thank you so much for being here. My name is Otis Landerholm. Today I'm going to be talking about to file or not to file. All right, to file or not to file my immigration case. That is the question. How to handle the risk of submitting a tough case today. All right, and so welcome to the Empowered Immigrant Live. My hope is to empower folks here today with this topic and really to help people think through the concept of risk in their immigration case. So welcome, thank you for being here. Remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. All right? And today our theme is to file or not to file. And really the question is, how do we navigate the risk that comes with submitting a tough immigration case today? And as we get into it, the question is, do you want to get a green card? Do you want to get citizenship? Do you want to get a visa? Do you want to get asylum? Do you want to apply for something? Do you want to figure out a way, a strategy, an option, a method, an approach to fix your immigration situation once and for all so that you can up-level your life and up-level the amount of freedom that you have in your life? Freedom to work, freedom to live, freedom to breathe, with less stress, and to travel and to enjoy your life through the immigration process. All right? That's the question. And if you're in that situation, and if you are wanting to find a strategy or an approach or an option, I'd love to help you with that. All right? My law firm, Landerholm Immigration, A.P.C., we're a law firm based in Oakland, California, and we fight cases nationally, and we have clients in other countries throughout the world, and we are on a mission. We're on a mission to win 10,000 cases for immigrants in the next 10 years. By 2035, we would love for your case to be one of them. All right? So thank you for being here. Welcome to the Empowered Immigrant Live. And, let's get into it. And as I'm talking about this topic today, if you have questions, send me your questions. I'll do my best to answer them right here, right now, live. And let's go. All right? So I'm filming this. It's the 12th of August of 2025. And I'm right here in my office in Oakland, California. I love the city of Oakland, California. I'm very happy to be here with you all today. And so here we are. And thank you for taking some time out of your day, out of your morning, out of your schedule to be here with me and to talk about what's happening in immigration law. All right, so it's August of 2025. We're approaching 8 months that Trump has been back in the White House, and there are lots of changes happening. All right, the Laken-Riley Act was signed into law. The One Big Beautiful Bill Act was signed into law. ICE has more funding and money than they've ever had before. They're getting started with their mass deportation efforts. All right. There's a new registration requirement. There's new travel bans. They've canceled TPS. People have been deported under the Alien Enemies Act, which is crazy. They've announced Project Homecoming. There's riots on the streets of LA. There's lots of craziness, lots of changes. And all of those changes, by and large, all of the changes that we're seeing increase the risk. And so it's important to discuss the risk. Okay? There's a risk. If you file a case, there's more chances that that case could be denied. There's more chances that when your case is denied, you'll be sent to immigration court, which are deportation proceedings. There's more risk that people that go to their deportation proceedings are going to be detained and put into some detention facility. The risks to your own freedom are increasing. All right? And so, but what do you do with the risk? Do you just say, okay, forget it, I'm not going to file? I'm not going to do it. I'm not going to file for my green card. I'm not going to file my asylum case. The risks are too great. Is that what you say? All right, that's a personal question. There's no one right answer there. Yesterday, I was meeting with a man with his wife, their 2 kids in the back. The husband is eligible for a green card. All right? But he has a petty theft arrest from years ago. All right? Which means that he's eligible for a green card, all right, through 245I. We could get into the type of case that he has. But simultaneously, he's subject to mandatory detention because of the Lake and Riley Act. All right? He could be detained if we file his case. That's a risky case. What would you do in that situation? What would you do? All right, you're eligible for a green card that could change your life and your future for you and your kids and your spouse and your family. And at the same time, you might have to be detained. You might have to be in jail for several months in order to get that benefit. And if you lose the benefit, they'll deport you. If you're in that situation, what would you do? All right? Also yesterday, I met with a woman who can file for citizenship. All right? She could file to become finally a U.S. citizen. But her case is not straightforward. It's possible that the immigration officer reviewing her case could allege that she was inadmissible at the time she got her green card. Why? She was working with an idiot, right? There was a misrepresentation that she made on a visa application from way back in the past, in the 1980s. And unfortunately, that misrepresentation from back in the 80s wasn't fully disclosed in the year 2001 when she got her green card. And so now 24 years after getting her green card, she could file citizenship and she could win citizenship, or some immigration officer might say, you made a willful misrepresentation of a material fact. You weren't 100% forthright when you got your green card 20 years ago, so we're putting you into deportation proceedings. Why? Because under Section 237A1 of the Immigration Nationality Act, you're deportable because you were inadmissible at the time of admission. Risk. What would you do? Would you file for citizenship in that situation? These are not easy questions, folks. These are not easy questions. How do you handle, how do you analyze, how do you think about risk in your immigration case? Every case is different. And here's the truth. All cases have some risk, especially right now. But here's the other truth. Doing nothing is also risky. Deciding to, I'm going to wait for like some future administration, also comes with risk. There's risk if you do something. There's risk if you don't do something. For the gentleman who's subject to mandatory detention, he's subject to mandatory detention right now. So there's risk to submitting the application, but there's risk to not doing it. And so how do you handle this? It's stressful. How do you handle it? The best advice is to get good advice. I say that a lot, and it's the truth. The best advice is to get good advice. So with my clients, we sit down, we talk it through. It's very important for me to discuss the risks with my clients and to think through strategies that we can take right now that could help reduce those risks. And we can think about and think through the benefits versus the costs versus the risks, so that we can be open and honest and clear about what we want for our future and whether or not it makes sense based on where we're at, and then we can make a decision. But here's the thing. I don't want anybody to make a decision based in fear. I don't want people to make decisions because they're an emergency and because I didn't make a decision in the past and now, oh crap, ICE is at the door knocking. Now I've got to decide. No, that's not the right time to start an immigration case. Instead, let's make a decision based on the rational understanding of what could happen and what we really want for our lives, for our future, knowing the risk involved. Okay? I'll tell you another story. All right? A few weeks ago, I'm entering a government building along with my client. And before we go in, I remind him, I tell him, I clarify for him, if you want your green card, we got to go into this building. But you are subject to detention. They might detain you in there. Are you sure you want to do this? And he looked at me and he said, you know something? I understand it. I'm ready to face it. And guess what happened? We went in, we had his interview, we left the building, and guess what? He now has a green card. It has changed his life. He now has a whole new sense of freedom, new opportunities to find new employment. He is able to start fresh with his wife, with their young child. It makes an enormous difference. But don't go in blind. Don't make that decision from fear. Don't make that decision alone. Get clarity. Understand your options and your risks. Get good advice and get good counsel. And that's really what I wanted to share today. And thank you so much for hearing me and allowing me to kind of share. This now more than ever is what our consultations are discussing. All right? Like, hey, let's explore all the options, but now let's explore the potential risk of filing those options, and hey, risk of doing and risk of not doing. And maybe now really is the right time, right? Or maybe it's not. And it's a very personal thing, and it depends on your situation. If you have a 5% chance of winning and a 80% chance of getting detained, then the best advice in that situation often is to not file your case. On the other hand, flip that. If you have an 85% chance of winning and a 15% chance of getting detained, maybe it's worth going for it. And that's a personal question. And that will depend on whether you want to go for that chance of winning immigration status to get this whole issue behind you once and for all. Okay? Food for thought. Thank you for being here. Really appreciate each of you. If you're just tuning in, my name's Otis Landerholm, and I'm a certified specialist in immigration law. I'm the founding attorney here at Landerholm Immigration A.P.C., where we fight for your American dream. I'm based in Oakland, California. We represent clients throughout the United States, and we have clients actually in the embassies throughout the world. And so I'm happy to be here. Really grateful to each of you for being here with me. And so let me get into your questions, all right? And I see some questions coming in. I'll take the rest of our time here, and I'll answer as many of them as I can, all right? So, Maria, I see your question. Based on your cases, how long is employment C9, based on an adjustment of status, taking for approval? You know, it's a good question. Part of it depends on the field office. Part of it depends on the service center that you filed at. But I say give it 5 to 7 months, typically, after you've filed a marriage-based case to receive your work permit through that marriage case, as long as it was well filed and it doesn't get rejected, etc. As long as there's not an RFE that slows the process down, yeah, typically 5 to 7 months. Okay? Quiros, you say, no sé qué dijo, pero miente. All right, I don't know what you said, but you're lying. Well, thank you. Thank you for that opinion. I don't think that there's a single thing that I said today that was untrue. Okay? So, but thank you for your opinion. Oscar, you said, can I travel inside the U.S. with my C9, Social Security, and I just want to apply for a real ID? Oh, you just applied for a real ID. Okay, I got that. And so if you have a real ID driver's license, then you are okay to use that to board an airplane. You're okay to travel within the United States with a real ID. Okay? And so, so yes. All right, that's my answer. Now, a real ID is different from your immigration case. Like, it is still possible, right? If you're stopped by immigration, it's still possible that they could say, hey, yeah, but what's your immigration status? They shouldn't do that, though, if if they don't have any reasonable suspicion or probable cause that you are in violation of any immigration status. Like, constitutionally, they should not stop people unless they have a reason for stopping a person. All right? If they base it on your race, for example, that is a violation of the United States Constitution. And you could challenge that, okay? And so anyway, that's a digression. Oscar, it seems to me like, yes, you can travel inside the U.S. with your C9, and especially when you have a real ID, now you can board an airplane using that document. You should be okay, all right? Worst behavior 811, God bless him, all right? And you say, I'm a U.S. citizen, but my wife is under DACA. Okay, I got that. She came to the U.S. very young without a visa. She has a pending case for advanced parole. What are the updates and the risk for travel right now? She has DACA. She came to the U.S. very young without a visa. She has a pending case for advanced parole. What are the updates and the risk for travel right now? That's a good question. That's a good question. We have done it, all right? The risks perhaps depend more on her personal situation. As long as she has no arrests, as long as she has super clean history, travel outside and re-entry on advanced parole is okay, all right? As long as she has her advanced parole document approved, right? She can do that and re-enter. She should be okay. On re-entry, she will have the parole entry, which grants her the ability to file for adjustment of status through her marriage to you. That's awesome. All right? And I have done that. I have won that, yes, even during the current Trump administration. It is possible. Fun fact, we filed a case. We got advanced parole knowing that Trump had won the election, and our client traveled right before Trump took power in January, re-entered on the day Trump was inaugurated. We were all nervous. And she re-entered, and now, shortly after, they filed the marriage-based green card adjustment of status, and that person now has a green card. All right? And so, just like, 8 months later, she won her case, I think last week. And so I was super happy about that. But yes, it is still possible. All right. Yes, it is still possible. So let's see. Are you romantic vibes? I see you're there. You say, how long are receipts taking? You're saying receipt notices for VAWA. I see what you're saying. So you file your VAWA application, you file your immigration application, and how long does it take to get the receipts? I say typically 60 to 90 days. All right? As long as it's not rejected, as long as it was well prepared, well documented, well filed, you should get the receipt notices within 60 to 90 days. That's proof that you have a case that's pending. All right? And then you can use that or show that to anybody who's asking, hey, what's your immigration status? Well, here's my pending application for immigration benefits, right? And so that's that. And then you said, sorry, meant how long are receipts for VAWA taking and the PFD, which is the prima facie determination. So the prima facie determination is harder to say, right? Typically, I would give it, and it depends on whether the abusive spouse, parent, or child was a green card holder or a citizen. Because if it's a citizen, then you're an immediate relative. If it's a green card holder, then it's a preference category case, which can take several years, all right? But the prima facie determination, it's talk to your lawyer, 1 to 2 years, right? About a year and a half, roughly speaking, for that, depending on several factors. But the receipt notices should come typically within 90 days. Hope that's helpful. All right, good. Let's see here. Oscar, thank you. You're welcome. Chapsticks 1, you say go Trump. Hey, believe what you want to believe. I very much disagree with Trump on his immigration policy. And we're here talking about immigration law. Other aspects of foreign policy and tariffs and things like that, I'm not as much of an expert in. But I'm here with my own beliefs about how immigration should work. And I love immigrants, all right? So I was an immigrant in 5 countries in the past. So I lived in Spain, Argentina, Japan, China, and Ecuador. And I studied in some of those countries, and I worked and lived in some of those countries. And it's not easy, right? Being a foreigner, being a stranger in a strange land. But one thing that I found is I really enjoy meeting, connecting with, getting to know people from other cultures. I really love meeting with and connecting with people who speak other languages, right? I love it. I love doing it. So much so that I wanted to go to law school to figure out how I can help people from other countries and cultures and backgrounds and how I can help them fix their immigration situation. And I've been doing it ever since for the last now 15 years. And so I'm happy, I'm happy with what I do and happy with who I serve. Emmy, I see your question here. You say, my daughter won a green card through the green card lottery. Very cool. Next year in March, she will be finishing 5 years old. Is it okay for her to travel or to apply for a citizenship now? You don't mean that your daughter is 5 years old. You mean that she's had her green card now for 5 years, right? Just confirming that detail. So I think that what you're saying is that your daughter now has had her green card for 5 years. If so, she is okay to apply for citizenship, right? As long as she doesn't have any arrests, as long as she doesn't have any exits outside the U.S. for more than 180 days, as long as she's a person of quote-unquote good moral character, paying her taxes, no arrests, etc., she can apply for a green card. She has to be over 18, though. So if she's actually 5 years old, then no, she can't. But if she's over 18 and she's had a green card for over 5 years, then yes, she can apply for citizenship. All right, worst behavior, 811, no arrests, clean history. That's good. I think you should be okay. All right, Diego, you say, I got prima facie. What is next? All right, so prima facie determination on a VAWA case, right, means that they believe that your case is likely to be approved. They just don't have the numbers yet. All right, so you still have to wait for the final determination of your VAWA I-360 petition. All right, but the prima facie determination can be used to, get a work permit and get other benefits that come preliminarily with VAWA. Okay, talk it through with your lawyer if you have more questions about that. But there are certain benefits. You can get a work permit, for example, Social Security card, apply for state benefits that are granted for people in that situation, depending on what state you're in, etc. So talk those things through with your attorney, and you can figure that out. Okay. Power off. I see your question. You say, "Hello, sir. You are the most honest lawyer." Thank you. I don't know if I do try to be honest, and there are, I'm sure, there's probably like the equivalent of the Mother Teresa of lawyers. I am not that, right? But I do try to be honest on this show. So thank you for saying that. Question, I was a lawyer back home. Okay, cool. I've been in the U.S. for 11 years, and now the government changed in my country. They've been targeting lawyers. Can I apply for asylum? Got it. Got it. Changes in the circumstances of your home country is one of the justifications or the reasons for filing an asylum case late. So let me explain that in a little bit more depth, okay? When a person seeks asylum because their life or their freedom is in danger in their home country, right? The rules say that you have to seek asylum within 1 year of your arrival into the United States. We call it the 1-year filing deadline. But there are 2 exceptions to the 1-year filing deadline that are in the law, passed by Congress, all right? One of those is what we call extraordinary circumstances. Imagine that you were sick or in the hospital suffering from cancer or something like that. Or imagine the COVID-19 pandemic happened right when you were preparing your asylum case and all the offices shut down, right? Those are exceptional circumstances to excuse the filing late. The other one, though, is if there's changes in your home country, such that now, imagine there's a coup in your home country or a change in regime in your home country. And so now they're targeting you. And now if you go back, the situation has changed. Now your life is in danger where it wasn't in the past. Then yes, that is a way around the 1-year filing deadline. It doesn't mean that you should automatically file for asylum. Asylum is risky, all right? You file, and if you lose, you're subject to deportation proceedings. Automatically, it's part of the process. And you can renew an asylum application in deportation proceedings in front of an immigration judge, and that's, my office does that all the time, all right? And we help our clients and represent our clients through that process. But my point, power off, my point is that yes, you could apply for asylum, but I'm not advising you right now over the internet without really discussing it with you. This is not legal advice. I'm not advising that you apply for asylum. Instead, I'm recommending that you have a detailed consultation with an attorney who you trust, who really knows asylum law, and who can give you that advice. Like what chances do you have of success on that asylum claim? What really is happening in your country of origin? How could we document what's really happening with lawyers in your home country, and whether or not being a lawyer in your country could qualify as a quote-unquote particular social group in your country for purposes of asylum, or whether or not you have a quote-unquote political opinion that could qualify for asylum, or whether or not there's some other argument that could help maximize your chances for asylum. You probably have arguments. Just talk them through with somebody who's good and who knows this stuff. And if you're looking for that person, feel free to contact my office. We love complex asylum cases. We love winning asylum cases, right? And so yeah, we're here to help. We'd love to help you. All right, Zemo7. You say, I was in removal proceedings, then my case was closed, and I have a U.S. passport. Should I be worried? So you're a U.S. citizen, is what you're saying. You've won your case, you've won your citizenship, you're a U.S. citizen, you have a U.S. passport. So if you are legally a U.S. citizen, you should not be worried, all right? If you're deported and you're a U.S. citizen, you can sue them, all right? And that's a wrongful deportation. And if that's the situation, call my office. We'd love to help you, okay? And if you were in removal proceedings, then the right thing to do is to not, quote unquote, close the removal proceedings. The right thing to do is to do what's called a motion to terminate your removal proceedings after you've won citizenship. So there is something that you might double check was done properly. Because if you just close your case, they're still there. That'll cause confusion, or it could. And it's so much better to terminate proceedings so you don't even have any case anymore. Okay? All right, very, very cool. And thank you for sharing that, Zemo7. All right, so I am never. I see your question here on Instagram. Thank you so much for being here. You say, my wife came in on a K1 and we are doing AOS, and I have an interview coming up on the 10th of September. Do we need to do an I-693 even though we didn't have to when applying because she did it in her country in less than a year ago? Good question. So I don't feel comfortable answering that question without reviewing the regulations there. I'm glad you did it in her home country for the visa. That might work. My question for you is, did you receive a new medical exam request? Like, did you receive a RFE or some kind of notification saying, hey, you need a new I-693 medical exam? I think that we often do a new medical exam once you're here and once you're going through the green card application process. Don't remember if the last time we did a K1, if we redid the medical exam or not. I'm sorry. You didn't get, okay, you're saying no, so you haven't received anything else. I mean, they'll tell you if you need a new one in your interview. All right, so one strategy is, hey, you just did it. Go to your interview. Best of luck to you in your interview. And if they need you to do it again, they'll give you a request for evidence, and it'll slow down your process a little bit. But that would avoid the need to go do a whole new medical exam. And if you really want the best advice, I would say talk it through with your lawyer. Or if you really want me to do that or my office to do that, feel free to give us a call and schedule a consult, and I could take a few moments and really get to the bottom of that issue from a legal perspective, because I don't want to say it incorrectly right here, right now, online. All right. So, but good question. Thank you for being here. Thank you for asking it. Either way, it sounds like you're in the right path and you've got the right process going. Typically, the I-693 lasts 2 years, and so, but I don't know that you did the I-693 when you were at the consulate or when your wife was at the consulate. Okay, and you say you'd love for you to review my case. I'll contact your office. You're so welcome, and thank you for that. We're here to help. We'd love to help. All right. So let's see here. Jesus, I see your question. No vayan con este abogado. No lo recomiendo. All right. Well, I'm sorry to hear that. I don't know if I did something to not earn your recommendation, but thank you for your opinion. All right. Let's see. So Zemo7, yes, yes, it was terminated. Okay, good. I'm glad it was terminated. So clavicular, you say, I have a U visa pending. I'm in removal proceedings, still awaiting receipts. What should my attorneys do? Let me think about that. You have a U visa pending. You're in removal proceedings. You're still awaiting your receipt notices. What should my attorneys do? Well, so they can't rely on a U visa in immigration court proceedings. All right. I'm glad they're doing it. It can be a good plan B. It can be a good long-term play. But the U visa is not an application that your lawyers can just depend on in court. All right. They've got to file for something that the judge can utilize, that the judge can make a decision on. All right. A U visa is, an immigration judge does not have jurisdiction over a U visa. All right. Common misconception. And so if you're in removal proceedings, you got to apply for asylum or cancellation of removal, or it could be VAWA-based cancellation of removal, or there's lots of different other things, motions to suppress, motions to terminate, contested removability hearings, 212C cases, 212H cases. There's lots of different applications that could be done in immigration court. And your lawyers really should be advising you about this. All right? And so if you are not getting good counsel and representation and all that stuff as you're going through your process, then, and maybe you don't have a strong case in front of the judge, but maybe you have a strong case for the U visa. And so maybe they try to put you on a status docket or administratively close your case because of the U visa. But those are difficult in this climate, all right? The judge does not have, an immigration judge does not have jurisdiction over your U visa. And that's just the way it is. Okay? I see your follow-up. You say the judge set an immigration hearing or an individual hearing after your first master calendar hearing, non-detained, to June 2026. Okay. All right, good. Check my comment here, please. Okay, I got you. And so I think that you've got some time, right, until June 2026, but your U visa will be pending for 30 years if it was just submitted. And so your lawyers will need to come up with a strategy. All right, your lawyers are going to need to come up with a strategy. You can't file for asylum because you're going to lose. You're from Italy. I filed it as a non-starter. I don't have a strong case for the judge. I have a strong U visa. Well, you could lose your case and appeal, right? It's like sometimes you want to preserve every argument possible for appeal, just in case, and then appeal while your U visa is pending. But yeah, it's possible that you'll lose everything. You'll lose, and this happens sometimes. And if you lose, and if you're actually subject to a deportation order, you might request voluntary departure in the alternative so that you leave the U.S. without a deportation order so that you can come back in once your U visa is approved, right? You got to be talking these things through with your lawyers so that they're really clear with you about what is the strategy. And if your lawyers aren't doing that, get a different lawyer. Right? Or just really meet with them and say, hey, look, you need to tell me what is the plan, because your lawyer needs to have a plan. Okay? All right, you guys, thank you. Thank you all very much for being here. Sorry, I feel like I had some negative energy on our podcast today. I guess that's happening more and more, but I am sorry for that. But I try to be a fairly positive guy and a positive human being. And I am an optimist at heart. And so I like to be that way. But thank you all very, very much for being here. Really appreciate each of you. It's Tuesday, the 12th of August of 2025. Let's make it a great day. If this content was at all useful for you, please take a moment and go to our channel in YouTube. And please subscribe to our channel in YouTube. All right? And when you do that, if you also hit the notifications bell, then you can receive a notification whenever we upload an additional video with news or updates, things of that nature. And if you have an immigration case, and if you want a second opinion, and if you want to really talk through your immigration option or your immigration situation, hey, please feel free to give us a call. We are here to help. We would love to help. All right? Thank you all so much for being here. Really appreciate each of you. Let's make it a great day, and we'll see you next time on our next episode of the Empowered Immigrant Live. Thanks a lot, everybody. Take care.